My name is Mary Bajo. I'm an attorney here in San Diego. I work for SD & Baumberger, a law firm here. We're a personal injury firm, and we represent victims of childhood sexual abuse. So today I'm going to be talking about an institution's responsibility to protect children from sexual abuse. So first, I'm just going to give you a brief overview. We represent children on the civil side of these cases. So before we get involved, there's usually a whole criminal process that happens. There's the police investigation, there's a trial, or the perpetrator will plead and they're put in jail. The goal in the criminal cases is to convict the perpetrator, to get them put away. The police department or sheriff's department is usually in control of the investigation, and then the district attorney's office will be in control of prosecuting the perpetrator. The victim has input in the case. They usually have to give testimony at trial, but they don't really have control over the process. But the criminal process is very important for victims because it provides a sense of closure. And then after that, there are times when the victim will also pursue a civil case, and that's where we get involved. In civil cases, financial compensation is the main goal for the victim. The financial compensation provides economic resources for the child going forward in the future. It's also to compensate for pain and suffering. And it holds not just the perpetrator responsible, but it holds the institution responsible. When I say institutions, I'm talking about school districts, youth organizations, religious organizations, child care facilities, foster family agencies and group homes, inpatient and outpatient care facilities, and sports organizations. What can institutions be held accountable for? Failure to report. Oftentimes there's mandated reporter laws in place in each state, and that means anyone who comes in contact with a child, anyone who has supervision duties over that child, has a duty to report immediately if they have a reasonable suspicion that that child is being abused. Because it's very important that the victims are interviewed by people who know what they're doing. These kids, they've been through a lot. Oftentimes they're vulnerable already. They may have past emotional problems. They may have been victims of sexual abuse in the past before this even happened. And so you don't want to make them relive everything if the interviewer doesn't know how to talk to them about what they're going through and what they've experienced. Throughout the whole process, civil, criminal, whatever, prevention is the main goal because we don't want this to happen at all. So when I say systemic change, what I mean is large verdicts and settlements, they send a message. They send a message to other institutions, they send a message to the community, they send a message to the victim. It tells the victim, we're validating your thoughts and opinions, we have your back, and we believe you. The civil process, it's also a very therapeutic and healing process for victims. Like I said, accountability is placed on those who are responsible for causing them harm. And again, that's not just the perpetrator, not just the person who may have sexually abused them, but it's the people who are responsible for watching out for them. Because again, we're talking about children. And for example, in a school district, parents are mandated by law to take their kids to school. And so when you do that, you drop them off and you expect that that school is going to be looking out for your child's best interest. And there's really nothing that you can do to make sure that happens. Oftentimes it's just a trust relationship. And so the parent wants to make sure that that school district and the school personnel are doing everything in their power to keep that kid safe. Once you file a lawsuit, it's public record. And these victims and their parents don't want the community to be able to look them up and say, oh, I know that person and now I know what happened to them. So the courts allow us to use fictitious names, so it's often John Doe, Jane Doe, things like that. Sometimes we'll use their first name and the last name Doe. But anyways, in this case, there were two boys, they were 13 years old, and both of them had issues with substance abuse, drugs, and alcohol. So their parents entered them into an outpatient treatment program at Pacific Health Systems, or PHS as I'm going to refer to it. So when they went to this program, there were what we call group meetings. So they had one-on-one counseling sessions with drug and rehab counselors. And then once a week on Wednesday nights, everyone in the program and their parents would get together and they would have an open meeting, an open session. And these boys were introduced to a volunteer there, and they were told by the counselors that this volunteer could be their AA sponsor. And when they were enrolled in this program, they had to find a sponsor and attend AA meetings. And so the boys show up and they're told, this guy comes to our meetings, he's helped a lot of kids here, and he can be your sponsor. And so of course the boys were like, that's great, now I don't have to go out and make a connection with someone and find a sponsor like you normally have to do. Unfortunately, what happened is this volunteer groomed the boys, and ultimately he ended up molesting them. So PHS introduced this volunteer, his name's Rob Poisner, to the boys and told them that he'll be their AA sponsor. The parents raised concerns because they thought, shouldn't my son have to go out and find a sponsor that he connects with? Shouldn't he find someone closer to his own age? And they were told, he's been coming here for a long time, he's helped a lot of kids, this is what he does. And your kid will get clean if you choose this man as, or if they choose this man as their sponsor. And so the parents trusted what the experts were telling them. There were numerous red flags that PHS ignored. For example, one of the most obvious, he was the only sponsor there, and he was also 39 years old. This was a program for kids between 13, well, some as young as 12, but these boys, they were 13. They were the youngest boys in the program at that time. So kids from 13 to 18 years old. And there was a 32-year-old man there volunteering to spend one-on-one time with them, go places alone with them. The parents raised concerns to the counselors and said, I think this is really inappropriate. What is a 39-year-old man? Why is he interested in helping my 13-year-old son? And the counselors, again, they said, you know, he's done this before. He's been through it. Let them work the steps with Rob, and he'll help your kid get clean. And that's what the parents wanted. They wanted their kids to get clean. Despite the numerous complaints, concerns that were brought up, the parents were reassured over and over again, and they were told, don't interfere. You're interfering with your kid's sobriety. Let the process happen. Let them work through the steps. They're going to be spending time late at night together, on the phone together late at night. They're going to be going to meetings together. You have to let that happen. You can't interfere. So, Rob Poisner was able to bring one of the boys back to his condo on 2 separate occasions. And each occasion, he ended up sexually abusing this 13-year-old boy. He also brought the other boy to his condo numerous times. And the grooming process with this other boy, it lasted longer. He ingratiated himself with the family. He started to become friends with this other boy's friends. He would tell him, oh, bring your friends over. We'll have a slumber party. You can just tell them you're spending the night at each other's houses. And so these boys did that because this man, Rob Poisner, he would give them alcohol. He gave them drugs. He let them drive his car. He would take them places late at night. He let them do whatever they wanted. He even showed them porn. This should have been and could have been prevented. There are numerous other avenues that PHS could have chosen. There are youth AA and NA groups where people can go and connect with kids their own age. And you can meet someone who's 18, 19, 20 years old who's been through AA or NA, who's been through all of the steps, and who's willing to be your sponsor. And it's more age appropriate. They also weren't supervising what was going on. That the safety of the patients was always paramount. But we know that wasn't the case here. Because if the safety of these boys was paramount, this could have been prevented. Because no background check was ever done on this in-house sponsor who was recommended to these boys. If PHS had done a background check, they would have seen that Poisner had 4 prior criminal convictions for peeping Tom activity. He'd been arrested and convicted 4 times for looking in windows. If they'd done their due diligence, if they'd looked into this person that they were recommending as a sponsor to young, vulnerable boys, because these boys were vulnerable particularly vulnerable because of their issues, their mental health issues, and their issues with their issues with substance abuse. If they had done that, then they would have said, you know what, this man's not fit to be a sponsor for minor children, and we're not going to let him into our facility. During the course of litigation, PHS made numerous claims. They claimed that they didn't have any knowledge of this man's propensity for sexually abusing children, but they never asked and they never looked into it. They also claimed that they weren't responsible because this happened away from our campus, it wasn't on our premises, we're not responsible for that. But what we know is that the grooming started at their meetings, and that if PHS hadn't introduced this sponsor to these boys, they never would have met him. And then, to top it off, they questioned the nature and extent of the injury and damages that these boys were claiming. They said, you know what, these boys had problems with drug and alcohol at 13. They had other issues going into this. So after nearly a month of trial, and the jury deliberated for 2.5 days, they returned a verdict of $6.5 million for the boys. The goals here, as always with civil cases, is financial compensation for the victim, like I said. And here we obtain that goal. But also prevention through training, supervision, and better policies. And also, not just better policies, but policies that are actually implemented. Because as we know, the program director said, safety of the kids is always most important. It's paramount. And that was in their policies and procedures, but it wasn't implemented. That program director also said, oh no, Poisoner would never have been recommended as a sponsor. He couldn't be a volunteer here because no one did a background check on him. And that may have been their policy, but it wasn't their procedure. This is just a sample of some of the cases that we've worked on at SD and Baumberger. Most of these tend to be school district cases where children are abused by someone, either a teacher's aide or an after-school person, or their teacher themselves. And just a note about these verdicts and settlements, when a minor gets a recovery like this, they don't get access to the money. It's usually put in a structured settlement or an annuity. They earn interest on it. They get payouts over their lifetime, and that provides for care and things like that going forward. I also want to touch on the changes that we want to accomplish overall, not just with each case. And again, that's prevention through training. That means taking the research that people in this room do and implementing it and taking what can be learned so that this can be prevented in the future. And that research and training can be put into school districts' policies and procedures, and they can make sure that these policies and procedures are effective because they're actually being acted out. And also, if they have policies and procedures in place, we want them to know that you better follow those policies and procedures, because having them written down doesn't do anything. You have to actually implement them and put them in place and make sure people on the front lines know what they're doing. Because oftentimes what we find out is that it's the people at the top levels, it's the HR, it's superintendents, it's the principals who know what to look for, and they know those red flags, but they're not the ones interacting with kids, and they're also not the ones interacting with their colleagues, because it's other teachers who are able to notice, hey, this teacher is spending a lot of time alone with this one student, and I've seen them in their room behind closed doors. And when the teacher sees that, that triggers that reasonable suspicion. And as a mandated reporter, they're required to immediately report that to either Sheriff's Department, Police Department, or CPS, or all agencies, just to cover all bases. School districts have an affirmative duty to prevent and protect children, and that includes protection from sexual abuse. And when I say affirmative duty, I mean it's not something that they can pass off to anyone else. It's a duty that they have to follow and they have to uphold. These are a few common issues that we come across in every case that we work on. Oftentimes what happens is there's an imbalance of power. So you have a teacher and a student, and the student's looking up to that teacher, and other students, all their peers, look up to the teacher. And oftentimes when this happens, it's not the creepy teacher that you think is probably doing this. It's not some, sometimes you see pictures of pedophiles in the news and stuff. It's usually the popular guy, the ones that people look up to. They feel good when that person pays attention to them because their peers respect them, and their parents often respect them. And that's what we're taught our entire lives. Trust and respect your teacher. Do what they tell you to. And so with that imbalance of power, these people can often take advantage of that, and they cross boundaries. From the research, we know that 1 in 4 girls will be sexually abused before they reach the age of 18, and 1 in 6 boys. And that's just from the research that we know. Oftentimes with sexual abuse, as you can guess, it's not reported. It's kind of a secretive thing. It's really hard for people to talk about, especially children. They don't want to come forward. They don't want to discuss it. They think it's embarrassing, and they feel shame. And because of that shame, they don't want to go and tell their parents. They certainly don't want to tell other teachers. They don't want their friends to know. So unfortunately, this is the data that we have at present, but the inaccuracy, it's staggering because, like I said, we don't know. There's also the myth that children are often abused by someone they don't know. And we've all heard the term stranger danger. And while it is important to teach your children about stranger danger and not becoming too close with someone that they're not familiar with, we know that most times children are sexually abused by someone that they know. It's either a family member or someone that they trust and someone they know well, or someone their parents feel comfortable leaving them alone with. And also one other thing I wanted to address, it's not just adults who sexually abuse children. About 1/3 of the sexual abuse that is reported is with peer-aged children, so children doing it to other children. And the scary thing about that is we have some cases where the children are as young as 3 or 5 years old, and a 3 or 5-year-old learns that from somewhere. If there was no criminal trial, you can still pursue a civil case. And there might be a myriad of reasons why there's no criminal case. It could be just that the district attorney didn't prosecute, or, they didn't come forward in time, again, because they're shamed and they don't want to talk about it. It makes it more difficult because in the civil case, the evidence standard, it's a preponderance of the evidence. It's more likely than not that it happened. In the criminal case, it's beyond reasonable doubt. And so if you have that criminal conviction, you don't have to prove that it actually happened. That criminal conviction is proof of what happened in the civil case. And so it does make it more difficult, but it's not impossible. How many times with those awards that we get, the verdicts or settlements, how often we can also include a stipulation to force the institution to change policies or implement better policies. But like I said, in the civil justice system, monetary compensation is usually our only option. We can affect that through settlement sometimes, but usually the award is enough to send a message either to the institution or the insurance company that the institution is insured by, who wants to go in and make sure this doesn't happen again, because they're the ones getting hit with these verdicts and settlements. They're the ones who don't want to make the payment, and so they can go in there and say, look, if you want to be insured, you have to make sure that this changes. And I can tell you, definitely with the LAUSD case, the one for $23 million, that verdict sent a message through all of LAUSD. I don't know if you know, that's the second largest school district in the country. And the district building, it's almost like a skyscraper. And they've implemented changes from the top down. And they're changing their training policies. They're changing policies on the front lines. And so when I said these verdicts send a message, I wasn't kidding.